So the agendas for the discussion in today's webinar would be the definition of MSMEs under Micro, Small and Medium Enterprises Development Act 2006. So how are these expressions defined under the Act? We'll discuss those, and the qualifying conditions for to apply for the registration under MSMED Act. So what are the qualifying conditions for an enterprise to be registered as a micro or medium or small enterprises in the Act? We'll discuss those also. The challenges and issues pertaining to delayed, defaulted, and stuck payments from buyers. We'll discuss this. And important provisions under MSMED Act for the benefit of MSMEs. And we'll discuss the solutions and way forward to resolve the issues of delayed payments, how these delayed payments issues generally occur in the first place, and how we can ignore and how we can ignore and avoid these issues in the first place by the modalities in our internal management of the businesses. So, and going forward, we'll discuss the preventive measures to avoid delayed payments, as I told you right now. The resolution mechanism after the delayed payment has already occurred. The issues of delayed payment has already occurred. So we'll discuss the resolution mechanisms, what all resolution mechanisms are there, the alternate dispute resolutions or online dispute resolutions. We'll discuss those. And lastly, we'll discuss the litigation provisions under various laws intended for recovery of payments or ways in which delayed payments can be recovered. We'll emphasize more on the resolution part of it, that under which laws and how we can recover our delayed payment, especially through the provisions of MSMEs, insolvency and bankruptcy and civil procedure code. So by emphasizing on those agendas, we'll just briefly touch upon the above agendas that I've already discussed, because all of these agendas are already taken care of and have been dealt in detail in our previous videos. And if you have any problems, you can any day just type Udyamita Helpline in YouTube and you can get host of videos posted by us in which we have dealt in detail all of these issues which are mentioned in the agendas, or which I have mentioned in the agendas. And now moving ahead. So the condition precedent to registered as MSME under MSMED Act. So what are the what how the expressions are defined under the MSMED Act? So firstly, we have to understand what an enterprise is, right? So the first category of the enterprise that I have classified is includes manufacturers and service providers both in one category. So all manufacturers of any goods are included in the enterprises, and as well as the service providers are also included in the enterprises. However, the enterprise as an expression under the MSMED Act is very much wide and open-ended, and all of enterprises who are delved in the business side are in a way would be covered by the purview of the expression. After
सॉरी टू
when
इंटरप्ट यू सर ठीक
sorry
ये जो चल रहा है वो करेक्ट है अभी
uh,
आपके अकॉर्डिंग ही चल रहा है ना
yeah.
आप मुझे बता दीजिएगा मैं चेंज कर दूंगी
Sure. Uh, we can do one thing. We
यस
can do one thing. You can just stop sharing this screen. I'll just read it out from my screen, because mine has the earlier presentation which I am referring to. So yeah, thank you. So the two parameters after in the second category after a recent amendment, which was in 2020, the MSMED department has also included traders of goods into the enterprise category, right? So now as well as manufacturers and service providers, along with the traders of goods are also included. Now the MSMEs enterprises definition has become wide enough to include every other business enterprises which are operating at any of the supply chain. However, be it a manufacturer of goods or a service provider, or even the traders of goods. So the trader of goods are are not manufacturing a good or not even providing any services, right? They're procuring goods from a manufacturer, and after factoring a profit they're selling it to the retailers. So neither they come into the manufacturers category or not they come into the service providers category, but still after the amendment in 26/6/2020, the traders of the goods are also included in the enterprises, the definition of the enterprises. The two parameters basis which the classification is made between the MSMEs are based on the investment made in the enterprises and the turnover made by the enterprises. So what are the parameters on which we decide how an enterprise should be get should be registered in micro category or a small category or a medium category? So that parameter is based on two parameters which I already said: the investment made in the enterprises and the turnover of the enterprises. Now the investment made in the enterprises generally deals with the plant machinery and equipments. It doesn't deal with the with, with the investment made in the land or other intangible assets, right? So, and the turnover part is also considered simultaneously along with the investment made in the plant machinery and equipments. So both the factors are taken together, and after it is decided, after according to the parameters, accordingly you can apply for registration in the micro, small and medium enterprises in the MSMED Act. So now I'll go to the investment made in the enterprises for micro, small and medium enterprises. What are the classification which is there in the MSMED Act, how it is defined? So any micro enterprises is defined. So the micro enterprises, the investment made in the enterprises should be less than 1 crore and the turnover generated annually should be less than 5 crore, and both these parameters should be met for you to apply for the registration as a micro enterprises. As and going forward, for the small enterprises, the investment made in the enterprises should range between 1 crore to 10 crore, and the turnover generated annually should range between 5 crores to 50 crores. And for the medium enterprises, the same range is between 10 crores to 100 crores in the investment, for the investment in the enterprises, and the turnover generated for the medium enterprises should range between 50 crores to 250 crores. Now, it can happen that your enterprise may be upgraded or downgraded basing on that that the investment in your enterprises has exceeded from 1 crore, or your turnover generated annually has exceeded 5 crores. So it 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 is not changed immediately, but the registration gets upgraded or downgraded in the upcoming year. So for the next year, your registration would be downgraded or upgraded. So it doesn't operate in the same immediate year. So going forward, the reasons for the delayed payments and its consequential effect on MSMEs. So there are a lot of reasons for these issues of delayed payment to occur in the first place, right? And we'll discuss those issues briefly, and we'll let you know how we can ignore and how we can check on these issues so that these issues doesn't arise in the first place, right? So the first is not documenting or recording of the transactions. So as I've stated that without any agreement or without any uh, written record of terms and conditions or how the transaction should go, many enterprises enter into transactions with other parties, and they uh, start manufacturing or start supplying the goods, or start giving services to the other party without any work order, purchase order, or any contract for that matter. So it becomes really difficult for you to, when the dispute occurs, for you to go to the neutral party and to make him understand that these were the transactions, these were the terms and conditions that were agreed between the parties, and this is how your payment is stuck now, or this is the interpretational issue that has arisen in the transaction. So without any terms and conditions written or recorded anywhere, the proving of that, uh, proving the other party's default becomes really difficult, right? Now the delivery of goods, materials, or performance of services without any work purchase orders. So as I stated, that without any work purchase orders, giving supplying goods or services is not something that enterprises many enterprises keep in mind, or take really good care of. But when these disputes occur, these transaction documents, the contracts and the work order and purchase order becomes a really important document because because it serves as a basis of how the transaction should go, of how you were engaged as a service provider or a manufacturer of goods, right? So not recording terms and conditions in an agreement or not adept with quick turnarounds for reserving rights, right? So we also have to be quick in our turnarounds for let's say ki, uh, when we supply goods to the other party, we must always send a confirmation letter by mail or even by hard copy that we have supplied the goods, and take a signature of the other party on, or take a acknowledgement of the mail that you have sent to the other party regarding the supply of the materials, right? So these are the quick turnarounds that you have to always be that you have to always keep in record, right? So if delays are occurring, not which is not attributed to you but to the other party, then you have to be quick with your turnarounds by writing them or by mailing them of this issue, that this issue is persisting, or this issue you are facing right now, that the contract is getting delayed for any reasons for that matter. But when we record these things, then it is quite easy for us to prove that these delays or these defaults were not attributed to us but were attributed to the other party. And in absence of these records and communications, all the transactions, uh, for us to make understand a neutral party that where the things went wrong is quite difficult, right? So in a brief, so 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 in a nutshell, you have to document and record the transactions, and the evidences of the transactions should be present and acknowledged by both the parties, signed by both the parties. These small things goes a long way when the matter goes into dispute, right? And coming to the second point, that is extended credit period. So I've seen a lot of enterprises extending credit period to the other parties. Now, the MSMED Act says that after 45 days of generating bill, if the other party has not make any, if the other party has not made any payment to you, after 45 days, the interest is calculated on that bill that you have raised to them. So extending credit period beyond 45 days must be a business decision. I completely understand that many a times smaller businesses extend this credit period to large corporate house, believing that the large corporate house won't default in their payment, and they extend the credit period for retaining the businesses, right? So it's always better for them to retain businesses than to realize the payment in 45 days in a timely manner. So uh, it should be a very conscious decision, and should be taken consciously by the businesses, and it should not be done liberally to all the corporate houses or to all the opposite parties with whom you're entering into any transactions, right? So the extended credit period, whatever it is, after 45 days, you're foregoing the interest that that was available to you according to the act, right? So always keep in mind that the extended credit period only collates your claim amount on the other party, and if the collated amount becomes large in number and then the other party defaults, then it becomes really an impediment for you to go for a dispute for that large amount, right? So it is always beneficial to keep the payment terms in a reasonable time frame. So let's say, uh, be it how long you extend it, always restrict it to around 3 months or 6 months for that matter, but not more than that, because extended credit period, you'd be foregoing your huge amount of claims that you must have gotten after the 45 days after the interest is applicable, just because you have extended the credit period now, and you have foregone your interest component. So you're foregoing a huge amount of claim that you could have gotten if the extended credit period was not that long, right? So the third is the challenges faced due to competition in the relevant market, industry specific challenges such as disrupted availability of raw materials, etc., competitive rates with minimal margins of profit. Now this is a very interesting issue, and no businesses can do anything about it, but to but what you can do is to ignore these things, and to avoid these things are that you can have a pool of vendors from where you get your raw materials, or from where you get your workforces. So uh, what happens is that in a given territory, uh, many competitors operate, right? So if I'm a FMCG and dealing with I'm dealing with food articles, let's say. So there are a lot of competitors already operating in the same territorial market, and it is always in the competition. Your prices would be in the competition, and your taste would be in the competition. So all of these competition, the healthy competition, how would you have an upper hand is by having a pool of vendors from where you can get your raw materials from, or having a pool of the workforces, uh, from the workforces pool from where you get your workforce, right? So a lot of times, as you have seen in COVID, availability of raw materials were disrupted, the workforce was disrupted. So all of these things helps in these peculiar circumstances for you to have an upper hand, where all the competitors, if they did not have the pool of the vendors, or the workforces, they would suffer, right? If any of these peculiar circumstances occur. But you having a pool of the vendors, you won't be completely relied upon any one or two vendors, right? So if they are not available, you can go alternatively to other vendors, or you can go alternatively to other workforces, so as your businesses is not hampered due to the disruption in raw material or workforces. So all of these things you should take care of, and by having a pool, all of these things can effectively be avoided, and you can have an upper hand in the competition in a given territory, right? So going forward, that no bargaining power with buyers to negotiate terms accordingly, market share reductions, alternate materials or service against that of MSME, etc. So the bargaining power with buyers to negotiate terms accordingly is an important point. So I've seen a lot of times that large corporate houses, when enter into a transaction with small corporate houses or small enterprises, the small enterprises do not have a lot to add, or a lot to ask for, because the large corporate houses can move out to another small vendors, right? Other small enterprises. So I've seen a lot of small enterprises, uh, in absence of bargaining powers, agree to onerous terms and conditions, like the extended credit period. So this is also a conscious business decision, and you have always to understand that these bargaining power, uh, should not be so much given leeway to the large corporate houses, so as they impose onerous terms upon you, right? So always we have to bargain, or we have to negotiate terms which are also beneficial to us, like the extended credit period, or some onerous terms like liquidated damages for delay in performance of the contract. But there is no liquidated damages for the delay when it is caused by the other party. So these terms you should look forward to, and these terms you should really negotiate with all effectively negotiate with the other party. And just because you have to retain the clients, we do not have to always agree to the onerous terms of the large corporate houses, right? So all of these things should be taken care of. Now, going forward, ineffective correspondences during a transactions, lack of recorded communication between parties, reserving the right to claim liquidated damages if any, lack of acknowledgement from the buyer regarding unequivocal acceptance, etc. So, in ineffective correspondence, as I already stated, that we have to be effective in our communication, during a transaction, right? So if any delay is happening, we have to write down to the other party that the delay is not attributable to us but is attributable to you. If any delay is happening in realizing the amount, and if the cascading effect, if the dominoes effect are that your business is getting hampered, or your credit line is getting hampered further, or further your credit line is getting hampered, or the salaries of the workforce is not getting on time. So all of these things that you have, that you are suffering just because your payment was not released on time, you can communicate to the other party that these losses are adding up to our cascading effect that we are suffering, right? So the losses are adding up, and when we do so, it acts as a evidence, so as to prove that we actually suffered these losses, and at the same time we have written these things to the opposite party. So it becomes a good transaction trace documents which you can rely upon as to prove your dispute, and as to prove your claim damages also. So in effect, effective correspondences is a must during the transaction. Whatever happens, whatever is going around in the transaction, you should maintain a written record, on an online platform, or on an offline platform. I would suggest to maintain it on both the offline and online platform together. So the last one is difficulty in realizing payments from buyers, cash transactions, etc. So the difficulty in realizing payments from buyers arises from all these issues that we have talked about, right? And there's one more is cash transactions. So whenever we do cash transactions without any proof of it, then it becomes really difficult for us to prove that the transaction actually occurred, right? So cash transactions is also good to be avoided as far as practically possible for all the enterprises. So all these are the reasons which are possible reasons for the delayed payment and its consequential effects on MSMEs, and all these things should be taken care of, and the effective management of these internal solutions can lead us to can can lead us to a lot of avoidance of these issues of delayed payment. So I cannot guarantee you that the issues of delayed payment won't occur at all, but if we effectively manages all these internal solutions, and we are adept in communicating, effectively communicating with the other party, we are quick with our turnarounds, we are quick with reserving our rights of claiming damages, then it becomes really easy for anyone to go and prove, or to set out the claim, or to set out the dispute between a neutral party, and to convince him that this amount is due, and the dispute is not the delay, or the default is not attributed to you but the other party, right? So moving on to the next slide, consequential effects to the challenges. So lack of financial resources. Whenever delayed payment occur, so when the financial resources is not being realized to the enterprises is also have to take care of a lot of things, right? So you have to pay salary to the workforces, you have to pay rent, you have to pay the bills that the the basic bills like water bills, electricity bills, all of these financial resources, the liquidity should not get hampered for any enterprises. So when any delayed payment issues occur, it also affects the whole liquidity flow of the enterprises, right? So it has a cascading and dominoes effect. You may have to take amount from other party on loan, or on interest, just to manage the lack of financial resources because your payment is stuck from the other party, right? So all of these issues have these consequential effects, and these things should be taken care of so as to avoid these consequential effects, right? So the second is lost claims due to not having enough evidence and materials on record to prove default. So as I already stated, that if we do not have any recorded communication, or any record as to say, then it is quite difficult for any party to go and to convince the neutral party that the claims that you are claiming have a basis, and how they came to be, right? Because there is no record. as to trace back these claims that you are claiming from the other party, right? So a lot of time the claims are lost and reduced substantially just because the records were not available, or there were not enough materials on record to prove that much of a default that you're claiming, right? So the claims being undervalued. So as this is the same thing, like if you have claimed 1 crore, but you have enough materials so as to prove only 50 lakhs of rupees, your claim would be undervalued. The 50 lakh rupees will be lost just because you were not able to prove, and or you didn't have any record to prove that 50 lakhs, in addition to the 50 lakhs that is there, more 50 lakhs would have been paid to you, right? So uh, the claims are a lot of time undervalued just because it just in the absence of proper documentation and proper records. Loss of damages liquidated from breach of terms of the arrangement by the buyer. So when we do not reserve our rights for the cascading effects, or for the liquidated damages that we are suffering due to the default payments, or the delayed payments. Now, a lot of times you cannot go at a belated stage and claim all those damages at one go, right? So you have to, when these things you are suffering, that your liquidity is getting suffered, or your cash transactions is getting suffered due to the delayed payment, we must write to the other party then and there that all of these losses we are suffering due to this delayed payment. And when it is done in a proper manner, then the loss of damages can be liquidated, and you can claim more damages from the other party on a lot of other heads, right? So a lot of other heads damages would include, if you're a contractor, let's say idlement of machinery, or price escalation of the materials that were to be used in the construction. So all of these issues have to be recorded and have to be communicated in an effective manner, so as to claim these things at a belated stage from the other party, right? So, and going forward, liquidity crunch in the operation of business, as I already stated, that the liquidity line is hampered, and all of the other material things that you had to do as an enterprise would be getting hampered, right? Just because you don't have enough financial resources, because your payment is struck from the other party. And going forward, not able to realize the actual amount as reflected in the turnover generated by the MSME, hampering the exact expansion and growth of the business. Now, what happens is, you have raised an invoice, and your turnover is based on the invoice, right? Or on based on the how many invoices you have raised to the other party. But on the paper your invoices on the paper your invoices would be collated, and your turnover would be exceeded by far. But the actual amount that you are getting against those invoices are not always the same as you have raised as the invoices that you have raised, right? So these differences in the actual realized amount and the actual invoiced amount is always there when delayed payment issues are there, right? Minimal profitability, just because the delayed payments are there, and you have suffered too many losses, the profitability would decrease, right? So the percentage of profit that you would have garnered if the payment would have come on time would substantially be reduced if the payment is delayed, right? So your profitability goes down. Going forward, not taking proper and relevant professional consultations, resulting in losses. This is one of the biggest issues that I have seen. I've seen a lot of awards that I continuously receive on my WhatsApp, in which they have already lost before the MSMEs. So I what I'm saying is, by taking proper and relevant professional consultations, you can avoid these things, right? You just go without any professional consultations, without any proper consultations, and you go and you fight the cases on your own without having the technical knowledge, or technical knowledge of how the disputes are to be managed, right? So I've seen people going to enforce an award of 2012 in 2023. So however, the limitation for enforcing an award is 12 years, but you waited 11 years to go and enforce the award. And the courts generally frown upon frown upon by entertaining these kinds of belated delays, belated claims, right? So these things are all always to be taken care of. The professional consultations is always going to help you and would necessarily avoid the things that you could not think of, because technical knowledge is technical knowledge of handling disputes, or to handle arbitration, or conciliation, or to handle resolution of disputes is pretty much important, right? Lastly, ineffective workforce due to lack and wastages of valuable resources. So I don't think this needs any substantiation that ineffective workforce leads to minimal profitability. So you have to take care of your workforce, that it's effective and it's operating in an effective manner. Legal troubles due to ignorance or no knowledge of various industry specific mandatory compliances. So a lot of times I've seen many enterprises doing businesses in specific industry area without knowing the specific mandatory compliances of that specific industry areas. So I've seen spices production units not complying with the FSSAI guidelines, or the compliances that they have to follow, or other uh, food manufacturing units not mm, ignoring the FSSAI compliances, so results in a lot of legal troubles. So a lot of legal troubles at a later stage, right? So we have to always be meticulous about what are all the compliances that are applicable to us when we are entering into a specific industry, right? So all the compliances which operates in those specific industry areas should be taken care of. Moving on to my next slide. Solutions and way forward to overcome challenges. Preventive measures and solutions to be adopted internally in an enterprise. So these are the cumulative ideas of what we have stated, that all the solutions and way forward to overcome the challenges of delayed payments. So I'll read it down, and I'll also substantiate it briefly, so as to give you a brief understanding. So the first is to enter into a written agreement, as I already stated, regarding the understanding of the terms between the parties, duly executed and properly stamped, notarized. So to enter into an agreement regarding the understanding of the terms between the parties, or to have a work order or purchase orders, those purchase orders are executed, properly stamped, or if there is an agreement, there is an agreement if it's properly stamped and notarized or not. So all of these things are pretty much important and should be taken care of. So going forward, work purchase orders to be raised under such agreement, work purchase orders to be shared on an electronic medium too, even if a hard copy of the same is raised, recording each and every transaction, its terms, obligations, applicable interest upon delayed payment, consequences of breach, force majeure, indemnity, dispute resolution clause, clause to notify defect or damaged goods and services, rectification period, unequivocal acceptance of work purchase orders if no defect, protest, or demur has been pointed out by the buyer. So all these things which I've read are nothing but the clauses that you can incorporate in an agreement for it to become a better agreement, right? So whenever an agreement is drawn, recording of these clauses is pretty much important. The terms of the agreement, what are you intending to govern the transaction, what kind of transaction that you're entering to, it should be written in the agreement in an effective way. And all these clauses should be well defined, the obligations of the both the parties, how what are all the obligations of the service providers or the manufacturers of the good, or the goods provider, as against to the buyer of the goods, from or as against to the buyer of the goods, right? Applicable interest upon delayed payment. So what are the applicable interest if the payment is delayed after 45 days period, right? So you have to mention that the 18.5% interest would be charged, or would be, the interest would be same as provided under the MSMED Act. So all of these things should be already written in an agreement if you're drawing an agreement. The consequences of a breach. So what happens if one of the parties breach or default any of these terms. All of these things should be well thought of and should already be incorporated, so that the transaction is governed effectively by that agreement, right? And when it goes into dispute, and the agreement goes to the neutral party for interpretation, the neutral party doesn't have to apply his interpretation, because there are a lot of gaps between the clauses incorporated in the agreement. So all of the things that you can thought of can arise, or can possibly arise in your transaction, should be incorporated in an agreement in an effective manner, so as to avoid any external aid of interpretation, or external help. So all the things would be governed from an agreement, right? And if the agreement is drafted in a better manner and in an effective manner, the neutral party at the court, the arbitrator, doesn't have a lot of scope to apply their own interpretation. And the uh, scope of not realizing the claim in an effective manner get reduced substantially, right? Because the agreement is drafted in a better way. The consequences of the breach I dealt with: the force majeure clause, indemnity clause, the dispute resolution clause. The force majeure clause is nothing but the act of God. So many a times, if you have to supply some of the goods, right, but your factory was the factory caught fire, and all the goods were burnt, and all the goods went down into the drain, because it caught fire. So it is your inability now that you cannot supply those goods, right? But it is not your fault, it was not under your control. So these things come in handy, uh, comes in handy when these things occur, right? When due to your inability, you are not able to perform the contract, but it was not something which you would have controlled anyway. So these clauses helps you a lot in those peculiar circumstances. The indemnification clause, right? So if the breach is not attributable to you and you have suffered losses, the cascading losses, or the liquidated damages, so the indemnification clause helps you in a way that if the breach is not attributable to you, the other party is obligated to indemnify you for all the losses that you have suffered due to his breach. So all these clauses are very much important, and if an agreement is drawn up, all these clauses becomes very much important to be incorporated in those agreements. The dispute resolution clause. So if the possible dispute is to be resolved under any agreement, how it is to be resolved, which courts would have the jurisdiction, which law would prevail, or whether it would be governed by the arbitration or conciliation, or any court would have the exclusive jurisdiction. All of these things is pretty much important to be incorporated in an agreement, so as to avoid jurisdictional issue at a later stage, right? So, and lastly, clause to notify defect or damaged goods and services. So a lot of times I've seen, when we supply goods, the other party, what other party does is they simply rejects the good by saying that we do not want your goods anymore, and we terminate the contract, right? So without assigning any reasons, they have the liberty to do so, just because we do not have a clause according to which they had to notify the defect or damaged goods if they received any defect or damaged goods. And if you have also a rectification clause, then the rectification clause mandates the other party to notify you of those defects and defaults which they found in your goods and services, and they would notify you, and they would give you a specific time period so as to rectify those default and defects, right? So these clauses are pretty much important, and kind these clauses avoids the possibility of the other party's scope, so as to goods rejects your reject your goods and services in entirety, and to terminate the contract without assigning any reasons. Now the second part is being adept with communications, reserving of rights to claim damages if any, receiving acknowledgement of the due amount from the buyer, taking steps to resolve issues before the claims are barred by limitation, follow-ups on delayed payments, balance payments, intimation of applicable interest, not diluting its right as a party by way of conduct, negotiating and careful of the agreed payment terms, whether advance the time of delivery payment within specified period less than or equal to 45 days. So being adept with communication, we already dealt with that, how communication is, how communication helps in establishing our case when disputes occur or when the cases of delayed payments occur. And when the transactions is recorded in a proper manner, it goes out, it sets out a story, and there are no possible other interpretations when it's already recorded, right? So when the events when happened, let's say a contract was for 6 months, and all the important dates of those 6 months when you supplied goods or when the payment was to be done by the other parties are already recorded, whether those events happened on those dates or not. So it sets out the story, right? And you cannot present other story with other interpretations when we already have a recorded events of those transactions. So the communication, proper communication is very much important in setting out your claim, or setting out your case, in case of any dispute before a neutral party or before a court, right? Reserving of rights to claim damages. I we already discussed this, that we have to be quick with our turnarounds, and we have to adapt with communications. Whenever we are facing losses, we have to let the other party know that these actions or these breaches has led us to suffer these losses, and when we do so, we reserve the rights to claim those damages at a later stage, right? Because we have suffered those damages. The receiving acknowledgement of the due amount from the buyer, right? So if the buyer is not making payment, timely payments, so what we can do is we can ask for acknowledgement that yes, this much amount is due, and this much amount is still to be paid to the other party, right? And if the payment is not made timely, and you have an acknowledgement of a due amount, by the opposite party, there is no possible reason for you to not claim an interest component on those delayed period, right? Because he has already acknowledged that default, and whatever delays might be now, he has to bear the interest component now. So acknowledgement of a due amount goes a long way in establishing the interest component, right? So if we have to understand this, and we have to take care of all these small issues that we let go of so easily, and these issues become a greater impediment for you realize your claim, right? At a later stage, the claims are barred by limitation. So this is one of the most important issue, and I would stress you to take care of this, especially because I've seen enterprises sleeping over their claims, and sleeping over their invoices. They don't file a reference, they don't go and consult any professional. They just keep on doing transactions, and they do not take any recourse as to recover their amount, right? And they keep on waiting for years to 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 do anything to recover their amount. So the limitation act is something that checks you and operates in these areas, right? And if you have to recover an amount from an other party, right? So the limitation for doing so is only 3 years. So for 3 years from the date on which the amount fell due, you have only 3 years to go and recover that amount before 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 the court or arbitral tribunal, right? So the limitations should be taken care of, because I have seen a lot of cases where the enterprises were sleeping over their rights, and they cannot do anything now, just because they have they are barred by limitation. The limitation period has expired, and now they cannot pursue their claims. So the limitation aspect of your uh, limitation aspect of recovering the amount is pretty much important for all the enterprises to take care of. The follow-ups on delayed payments, you have to consistently follow up on your delayed payments, right? So a lot of times, just because of our laid back attitude, and we do not want to press a lot on our delayed payment issues just to retain the clients, we forego the delayed payments for a long time, resulting in resulting in getting barred by limitation at a later stage, right? So we have to consistently follow up and take care of the limitation period as well. the balance payment intimation of applicable interest. So we have to intimate them that the interest would be applicable after 45 days if the payment is not coming within 45 days. All of these communication would go a long way in establishing your claim at a later stage or whenever the dispute arises, right? The negotiating of the agreed payment terms should be very much taken care of. Like I already stated, that the MSMED Act gives 45 days of time for the buyer or for the buyer to make payment to the supplier, right? After 45 days, the interest applicability starts. The application of the interest starts after 45 days, the expiry of 45 days. So there is no reason as to why you should extend your credit periods beyond 45 days. So if possible, I would suggest you to keep your credit period limited to only 45 days because the act mandates it so. Next slide is taking proper consultations from relevant professionals to have a legal secretarial audit and verifying the industry specific mandatory requirements, compliances under different statutes, incorporating effective ways to execute agreements, communication, follow-ups, receiving acknowledgement against purchase work orders and delayed payments. So this is also quite important because I've seen enterprises dealing with the legal problems by themselves and only to later regret because they didn't have any technical knowledge to do so in the first place. I've seen an enterprise which was barred by limitation, and I don't know what prompted him to sleep over his right, because he was so much confident that his under limitation and the limitation period won't operate as in a way he thinks it to be, right? So a lot of times your knowledge in a given circumstance, in a given peculiar circumstance, is not correct as per the established legal principle, right? So it is always uh, preferred, it is always good for the enterprises to go and to have a proper consultations from relevant professionals. So if you have any taxation disputes, or if you have any filing disputes, you should go to a CA. If you have any legal disputes, you should go to any lawyer or an advocate for consultations. And you should not trust your own judgment as to that you will do it on your own with the same effective way, with the same effect as any lawyer or any relevant professional would take it forward, right? So this has to be taken care of. The second is to carefully assess damages clause in the agreement, competition of claims under various heads such as price escalation, overhead charges, machinery and workforce, idlement charges, etc. So why do I say that proper consultations is pretty much important? Because many a times you have to assess damages under various heads, and without technical knowledge, in absence of technical knowledge, you cannot think of all the heads under which you can claim from the opposite parties, right? So as to price escalation, overhead claims, machinery and workforce idlement. So all these heads are there, and if you are into construction businesses, you would have heard these terms, right? So all of these assessment of claims are taken care of by relevant professionals, and they would be at a better position to assess your damages and to compute the claim, in a better manner, so as to have a better chances at succeeding in the dispute, right? So this has to be taken care of, right, by all the enterprises. To be well versed with all the schemes, benefits, policies by the government affecting MSMEs. So all these schemes, benefit, policies also operates that many policies are 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 given by the government, which are industry specific. All the benefits and the schemes, all of which cannot be ca- cannot be recorded, or cannot be known by an enterprise, right? Because he is into businesses, and you have to have a relevant professional, so as to uh, so as to not let you miss all these benefits, schemes, and policies just because you didn't know them. The next one is to safeguard the interest of business, creating strategies, strategic assets, raising proper invoices with GSTIN, UN, PAN, and be updated with statutory tax and other filings. So all these statutory tax and other filings, if you're a company, you have a host of other filings that you have to do before MCA. You have a statutory tax filings in GST and ITR. You all these things, how invoice is to be, how invoice is to be issued, GSTIN should be there, UN should be there, PAN should be there. All these small details goes a long way. Goes a long way for an effective management of a businesses, right? And all these things would come to you. All these things would be effectively be known to you after you have consulted a relevant professional who is well versed with all these issues, right? Now, next, to create outreach with online presence, new clients, buyers, proper and reasonable pricing, strategic business decisions, proper invoicing, not continuing to supply your services in cases of delayed payments. So all these are business decisions. So I do not have to substantiate that you have to outreach and you have to make an online presence in this digital era, and it extends it extends your presence, and it doesn't restrict your territory. It doesn't restrict your jurisdiction territorially as you would have restricted if you only had offline presence, right? So having an online presence enhances your jurisdiction to deal with clients which are not necessarily situated in the same territorial area as you operate in, right? To have new clients, new buyers, proper and reasonable pricing, all these issues are to be taken care of, and have to be made by conscious business decision. Being adept with follow-ups for payment, I do not think that this needs any substantiation. Now that we have to follow up for the delayed payments to the other party, if it is delayed, we have to write then and again that the delayed payment, that the payment is delayed, and the applicable interest is already operated, and all these follow-ups would be recorded, and would be beneficial at the time of you going and claiming the damages, right? Now, acquiring a post-dated check for the bill raised as a security measure to avoid delayed payment. Now, what you can also do is you can take post-dated checks from them. So, whenever the extended period is to be terminated, whenever it ends according to your agreement or work order or your purchase order, what you can do is you can take a post dated check from them after the credit period is ending, right? So when the payment is not made within the timeline as was agreed between the parties, what you can do is you can tender that check, which is already post dated after the credit line is ending, to the bank, and you can keep it as a security measure, so as to have something as a recourse to. So you can go to the bank and tender the check for the payment, right? If the other party is not making the payment by himself, you can go to the bank, and you can present the check that you have received from the other party, and if it is on it, you will have recourses under Negotiable Instrument Act, which we would discuss in some time. So now we have come to the external solutions, resolution of disputes when disputes have already arisen, right? So we have litigation, alternate dispute resolution, and online dispute resolution. Online dispute resolution is nothing but a way of alternate dispute resolution. So we'll discuss recourses from MSMEFC as per the provisions of MSMED Act, the proceedings under Section 138 of Negotiable Instrument Act, Insolvency and Bankruptcy Code, alternate dispute resolution or online dispute resolution under Arbitration and Conciliation Act, and lastly, the most classic way of recovering the dues, the civil suit for recovery of money, and the summary suits and summary judgments, which are part of the Civil Procedure Code and Commercial Codes Act. So we'll move to the next slide. Yeah. Reference to dispute to MSEFC, the relevant and important provisions of MSMED Act. Section 7, the classification of enterprises. Section 7 of MSMED Act classifies the enterprises, right? It says about the micro enterprises, small enterprises, and medium enterprises. It again says the same thing which we discussed in our second slide, that the turnover, where it should range from the turnover and your investment in plant and machinery for micro enterprises, the investment in micro the investment in plant and machinery and the turnover for small enterprises, and the same for medium enterprises, right? So that is how section 7 classifies the enterprises. The section 9 is measures for promotion and development. So all the measures for promotion and development of MSMEs are given under the section 9. The section 10 is the credit facilities that the government provide for the MSMEs, which are which are which is in the section 10 of MSMED Act. Section 11 is procurement preference policy. So section 11 is nothing but the preference which the MSMEs get in tendering or in procurement of government contracts, right? So they have a preference in almost all government tenders. At least I have seen that they have a preference in almost all government tenders and procurement agreements. That even if they are not the lowest bidder, uh, they are given a some sort of percentage that they have a preference over, right? So even in cases that they are not the lowest bidder, there might be a possibility that they can secure the tender or the agreement. Section 12 is funds, which to be how the funds and what all the funds to be given to the MSMED for the promotion and development of the MSMED. The section 13 is the grants by the central government. The grants, how the central government comes out with the grant, specific grants for the MSMEs. As you have seen, a lot of grants were issued at the time of COVID, right? And even after that. So all these grants are covered in section 13, which are issued by the central government. Section 14 is administration and utilization of those funds. So how it is to be administered, how it is to be administered and utilized the funds or the grants of the central government. Section 15 is liability of buyer to make payments. So Section 15 says that the buyer is liable to make payment after he has received the goods or services from the supplier, and after 45 days, within 45 days. So it's the liability, the section 15 says the liability of the buyer to make payment to the supplier of the goods within the period of 45 days. The section 16 says the date from which and rate at which the interest is payable. The section 16 states that after 45 days, the amount the after rate from the amount fell dues, after 45 days from the date the amount fell due, the interest is calculated, right? So I raised invoice today, and after 45 days from today, the interest would be calculated upon the invoiced amount, right? So and if that is not paid within the time limit of 45 days, which is given under the act, the interest and at what rate that the interest would be payable. So it clearly states that the interest would be payable as 3 times the notified rates of the RBI, right? So it operates around 6.6 point something. The RBI rates, the banking rates generally ranges from 6%, right? So the 3 times of 6% is 18%. And this 18% is not simple interest. This 18% is compounded at a monthly rest, right? So this is the interest rate which is given by the act itself. So the act states that this is the rate at which interest would be payable by the other party if it is not made, the payment is not made within the period of 45 days. Section 18 is reference to MSEFC. So when a issue of delayed payment has arisen, that you have not received a payment after 45 days from raising an invoice, and let's say that already 1 year hasn't passed. So what you can do is, under section 18 you can make a reference to MSEFC. So MSEFC Samadhan is also a portal under which under which you can go and file a reference online. You have to fill uh, certain information that they ask from you regarding your enterprise and the opposite enterprise. You have to upload some of the documents, relevant documents, like the invoices, work order, purchase order, the the bills, or the relevant communications that you think are important to the case. So all these things should be all these things make a part of the reference, and after making a reference to the MSCFC receives, and it examines the document at a preliminary stage. And if it is convinced whether the documents are proper, and there are no problem with the documents that you have submitted and the information that you have submitted, they issue a notice to the opposite party to make payment of whatever claim that you have asked from them, or that whatever claim that you have raised from them, right? Or they ask them to give a reply that why they think that the payment should not be made. So if they reply to that notice, you have an option of giving a rejoinder reply, or if they do not give any reply to the notice, and they do not even make the payment within the 30 days of the notice, because the notice gives them 30 days period give to give a reply or to make the payment. And if they do not make any reply or even payment, the dispute goes into conciliation. Conciliation, the MSCFC, what it does is acts as a conciliation itself, or gives the reference to another conciliator who are impaneled or paneled with the MSCFC. So the conciliator, what it does is it sits and it facilitates the communication between both the parties, makes them help reach a mutual settlement, so as to settle the dispute without going for the further proceedings, right? So that is the last shot of the MSCFC itself, uh, to settle or to facilitate the settlement between the parties, right? And the provisions from which the conciliation are governed are again the Arbitration and Conciliation Act. The conciliation part of the Arbitration and Conciliation Act are applicable in the conciliation proceedings of MSCFC. The section 19 is application for setting aside decree, award, or order. So whenever the conciliation is happening and the conciliation also fails, if the both the parties are not reaching a settlement, or not settling the dispute, not reaching an amount which not amicably reaching an amount on which they want to settle, the conciliation fails automatically, right? And the dispute goes in for arbitration. Now arbitration is a lot different from conciliation, right? Because conciliator does not have a lot of authority as to direct the parties to reach a settlement, right? He only can act after the parties have settled the issue. Now the conciliator can draw a settlement agreement, and when it is signed it becomes a decree, right? And it cannot be challenged also. The settled if a settlement agreement is signed between the parties have agreed to settle the dispute, and now you have signed also that okay, on these terms and conditions I've decided to settle this dispute, and I on these terms and conditions I've decided to settle this dispute, and you have signed it, agreed to it. Now there are exceptionally limited grounds and on which you can challenge it. Virtually you cannot challenge it altogether, because you have already by yourself agreed to that terms and conditions, right? You yourself agreed to that settlement. And if it is not settled, then it goes to arbitration. Arbitration is a lot different from conciliation, because arbitrator has an authority. Arbitrator would preside over our disputes and would decide upon the dispute. He would ask for the pleadings, he would ask for the documents from both the parties, as to how they think, as to give them the statement of claim. They would ask from the supplier their statement of claim if they have, or the statement of defense, any pleadings that they have regarding that dispute. The arbitrator invites those pleadings, and he goes through those pleadings, and after analyzing all the documents, all the records, all the materials before it passes an award basis on all the documents which are available, basis on the claim that you have, basis on the defenses the other party had, it passes an award by analyzing both the submissions of the both the parties, and that award is binding on both the party, right? Now uh, it is not something which you can easily go and challenge, right? Because section 19 is there. Section 19, what it does is, like, you have a recourse to challenge the arbitral award even in 34, and read with section 19 with section 34 of Arbitration Act, you can very well go and challenge an award. But but challenges to an arbitral award are very much limited to appeal, as against the appeal of a court order, right? So the as against appeals of court order can can be on a basis of fact or can be on a basis of law, right? So, but here it has a very limited ground, which is stated already in section 34 of the Arbitration Act, and only on those grounds it can be challenged further. Even courts do not meddle with the awards, do not interfere with the awards just because it is not legally correct. Even the certain legal principle is, even if the arbitrator has provided enough reasoning which is logical enough for the courts, then the courts do not expect the arbitrator to be as much legally sound as courts, right? So even if the interpretation is not legally tenable, it is not necessary that the arbitral award be set aside, right? So the setting aside of the arbitral award, the grounds for it are very much limited and are given under section 34 of Arbitration Act. But section 19 casts an extra obligation, right? So if you have an award passed against you, or an opposite party lost an arbitral award to you, you already got an award of let's say 1 crore to be taken from opposite party, which defaulted in your payment, right? So now if you have an award of 1 crore, and if the opposite party wants to challenge that award, so he has to challenge that award mandatorily after submitting 75% of the claim amount, right? So now he cannot go just for the sake of it, just for the sake of challenging the award, he cannot go and challenge the award, right? So only those claims which are genuine and which are valid as per their own view goes into appeal, because anyway they have to submit 75% of the claim amount right away, even to challenge the award, right? So many parties, what they do is they settle the dispute after getting an award, or and they do not challenge it because they have to submit 75% of amount anyway for challenging that dispute, right? So it is always beneficial for them to get it settled, or to pay off the entire amount at that instance only, without appealing or without challenging that order, right? So that operates as a very beneficial element to the MSEFC, because the awards are not challenged just for the sake of challenging it, or to halt the claim, or to halt your recourse, or to recovery of your money, right? So if they want to challenge, they have to mandatorily submit 75% of the claim amount before the court. So if they have to submit it before the court, what the party prefers, that they pay the same amount to the other party, and they settle the dispute altogether at that instance only. And section 24 is overriding effect. So the section 15 to section 23 of MSMED Act has an overriding effect of all the other act which were enacted before the MSMED Act. So even if there is a contradiction between the provisions of Arbitration and Conciliation Act, let's say, with the contradiction between the provisions of MSMED Act as against Arbitration and Conciliation Act, just because Arbitration and Conciliation Act came to be in 1996 and the MSMED Act came to be in 2006. The MSMED Act has an overriding effect over the Arbitration and Conciliation Act. That is the reason you would have seen that even after the existence of independent arbitration clause in an agreement, you can surpass that arbitration clause and you can file the claim before the MSEFC, and the MSEFC would have the jurisdiction to deal with it, right? So that is the reason why the MSMEFC has then overriding jurisdiction over the Arbitration and Conciliation Act. That is why the jurisdiction of MSEFC is there even after the existence of independence arbitration clause, or even arbitration agreement. So I believe that this part is clear. If you have any questions regarding this MSME related provision, you can ask me right now, or I'll move ahead to the other laws. Shall I move ahead, Richa?
Yes, sir.
Okay, thank you. So as I already stated, that there is a way of securing an amount by way of securing PDC. So if you have, let's say, 45 days of credit period, of receiving amount from the opposite party, right? So what you can do is you can take post dated check from that opposite party after the expiry of that 45 days. So the date in the check should be after the credit period, right? Because the credit period operates till 45 days. So if you have a PDC dated after the credit period expires, and you do not get a payment from the opposite party, you can go and you can tender the check to the bank. Now what can happen? Two things can happen: that you can get the payment. If you get the payment, well and good, the opposite party didn't have to pay you, didn't have to follow up, you just went and you tendered the check and you got the payment, right? So it's well and good, no issues on that. No issues on that aspect, right? So the other way is that it gets dishonored due to insufficiency of funds, or due to some other accounts, right? So if the check is getting dishonored, you have a recourse under section 138 of Negotiable Instrument Act, which is dishonor of checks for the reason of insufficient funds, etc., in the account. Which and Section 139 is the presumption in favor of the holder. So what Section 139 states is that whoever is holding the check, the law presumes that the opposite party had some liability, and in furtherance to extinguish those liability, he has tendered the check to the check holder. So the presumption acts in the favor of the check holder. So if I am holding the check, if the check is in my favor, so the law already presumes that the party who has issued the check to me was under some liability. It would fall upon you to prove the liability of what kind of liability was he under. So to give that check to you, but the law already presumes that there was some liability in furtherance of which this check was tendered to you by the opposite party. So this section is beneficial for all the check holders, because whenever the insufficiency of funds, the check dishonors due to the insufficiency of funds, we can have simultaneous civil and criminal actions, right? And section 142 is the cognizance of offense. Then who can take cognizance of offense? The complaint, the metropolitan magistrate or the judicial magistrate first class has the authority to take the cognizance of the matter, right? So and I'll let you know the process through how you can issue a notice, and how the actions of section 138 are taken care of. So whenever you present a check, and if it is getting dishonored, you are presented with a memo, a small memo from the bank, in with which they tell you that the check has been dishonored due to insufficiency of funds. Now, at the date on which you have received that memo, you have to within 10 days write a notice to the opposite party for the payment of the dishonored amount. That you demand the amount, that the check which was tendered by you has already been dishonored due to insufficiency of funds, and now that you want him to make payment within 30 days of time, right? So that notice is mandatory under law. So and the limitation of it cannot be extended. So always keep this in mind, that it has to be done within 10 days, and this notice is mandatory. If you have not issued a notice within 10 days, or a notice in those 10 days, then the action under this section gets diluted, gets extinguished. You cannot move ahead, because there are things that the compliant mandatory compliance you also have to take care of. And these are the mandatory compliances that you have to look for, right? And this is, as I already stated, that this is criminal offense as well as entails civil ramifications. And the action, again, under this section, can be taken against both the enterprise and the signatory of the dishonored check, right? So even the partner, the director of the enterprise, would severally be liable, or can together would be liable with the enterprises. Now you can pick and choose against whom you can move, right? You can move against the enterprise, or you can move against the director uh, of those enterprise, or you can move against both of them at the same time, right? So you can pick and choose, because the liability is not only upon the enterprises because of its separate legal entity, but it extends to the director also in his personal capacity. Moving ahead, it's recourse under Insolvency and Bankruptcy Code. It's 2016. The section 5 clause 21 defines operational creditors, and the creditors which are which would uh, the creditors which would be under the purview of the MSMED Act would always be operational creditors, right? Because you are service provider, or you're supplying any goods to the other party, or you're a trader, right? You won't be ever be regarded as a financial creditor, because it is defined in section 7, and it deals with whole other creditors, right? Those who deal in finances, or deal as a guarantor, those are the financial creditors. But the operational creditors are the service providers, the employees of the company, or someone who is supplying goods to the company. All these creditors who contribute to the operations of the company are termed as operational creditor, right? And they're defined under section 5 clause 21 of the Insolvency and Bankruptcy Code. So how does the operational creditor maintain a file for insolvency against any corporate or LLP? And another thing to be kept in mind is that the Insolvency and Bankruptcy Code can only operate against a corporate, be it public or private, or an LLP. Now you cannot maintain an Insolvency and Bankruptcy Code application against a banking company, or let's say against a trust, or let's say against an educational society for that matter, because it only can be maintained against a company, or an LLP. So section 8 is insolvency resolution by operational creditors, mandatory requirement of a notice to corporate debtor. So section 8 states that you have to issue a notice to the corporate debtor first before filing of a insolvency application under section 9, and you have to it is given under the form. There is a way how you can issue a notice. The the draft of which is given under the Insolvency and Bankruptcy Code, like how that notice is to be issued to the corporate debtor is provided already under the Insolvency and Bankruptcy Code, right? And in that format itself, you have to issue a notice to the corporate debtor demanding that payment, and giving by giving a brief of the dispute, and how the debt came to be. And all these information, the notice is issued to the corporate debtor, and 10 days time is to be given. After 10 days, in those 10 days, the corporate debtor can make the payment, or can refer that the claim is disputed, right? So it can do two things. And if within those 10 days the corporate debtor do not pay the claimed amount, or not even issue a reply referring the claims to be disputed, then in section 9 you can file an application for initiation of CIRP by the operational creditor, right? So there are two ways. If section 8, after getting the notice, the corporate debtor makes the payment, right? Makes the payment, then it's well and good. What happens is that a lot of time the corporate debtor would say that the claim is disputed. Now what do you mean by disputed, right? So it has been held in a lot of judicial pronouncement that a dispute should not be a frivolous one, but it must relate to a dispute. So if any issue regarding to the claim that you have is already pending before a court, or is already pending before an arbitral tribunal, then it can be stated to be a dispute. Otherwise, it any reference to a dispute just the sake of saying it to be disputed is not regarded as a dispute under the Insolvency and Bankruptcy Code. So this has to be kept in mind, right? And section 14 is moratorium. This is an important section, because Insolvency and Bankruptcy Code also has an overriding effect, just as the MSMED Act. And as you already know that MSMED Act came in 2006 and Insolvency and Bankruptcy Code came in 2016. So even if you are an MSME and you have filed a reference before the MSCFC tribunal or the Micro Small Facilitation Council to recover your amount, and there is some other creditor of that same company which files an insolvency application. So the insolvency application, after it is being admitted, when the insolvency application is admitted by the NCLT, when the NCLT admits and says that the CIP is getting started, the moratorium starts apply. The moratorium applies, right? The moratorium, the period of moratorium starts. And the moratorium is nothing but a staying of every actions which was against the corporate debtor anywhere, as to speak, except the criminal liabilities, right? So all the civil liabilities would get stayed. Your proceedings under MSME would get stayed. Your proceeding under any court would get stayed, and all of that claim would have to be taken under insolvency and bankruptcy code. So you being a claimant now have to submit your claim to the insolvency resolution professional, because the insolvency and bankruptcy code has an overriding effect. All the claimants have to come to insolvency and bankruptcy code for their recourse, and now they cannot continue with the same recourse that they were, right, before the initiation of CIRP. Now section 21 is committee of creditors. Now the committee of creditors, there are two kind of creditors that I already stated, right? The operational creditors and the financial creditors. Now the committee of creditors only are consisting of financial creditors, right? The committee of creditors do not have any operational creditors, so as to speak. But the whole power, what the insolvency and bankruptcy code does is it removes the faulty management, which it held accountable for this situation of a company where it could not pay the dues of operational creditors and financial creditors on time, right? So insolvency and bankruptcy code removes that defaulty management and replaces them with an insolvency resolution professional. Now the insolvency resolution professional replaces the whole board of directors. The power of the board of directors are assumed by the IRP, and the IRP, what he does is forms a committee of creditors. So all the financial creditor would be included in that committee of creditors, and the board of directors would be would be replaced by the committee of creditors. The committee of creditors would act as a board of directors, right? And now what happens is, in the CIRP, all the claims would be collated. The IRP would invite the claims from all the claimants that are there that are present against the company, right? So let's say Centex, which already went into CIRP, goes into CIRP, then the IRP of Centex would invite claim from all the claimants, from all the claimants that the Centex have, right? From all the claimants who asks money from Centex, right? So they would invite claim from all the claimants, and after receiving all the claims, they would collate all the claims, they would collate all the assets of the company, and they would release an information memorandum in an open market for the other players to to revive the company, right? To pay off the debts of the claimants as collated, because now they can see, right, that the collated debts are this much and the assets are this much, right? And now they have the whole information about the company, and if they want to buy the company as a whole, they can buy the company as a whole from open market. Now what they do is they offer a resolution plan. The resolution plan is a plan with which they propose that they would resolve the debts which are there in a given manner, and they would revive the company further. So if the committee of creditor believes that the resolution plan is good enough for them, and if they agrees to the resolution plan submitted before them, and then the company is revived, and the resolution applicant is successfully taken over the company, and the company gets a clean slate. Now the company doesn't have any debts or anything for that matter, right? Now there is one thing which I want you to know, that the committee of creditors only consists of financial creditors and doesn't consist of operational creditors, right? So the financial creditors, they do not have any reasons to they do not have any reasons as to why they would think of the benefits of the operational creditors that much. So there are a lot of times when the operational creditors do not get the full realization of their money, whatever they had claimed initially, right? So a lot of times you'd see that the operational creditors would only be able to get a percentage of a claim that what they had initially claimed for the IRP, right? Because the financial creditors get a lot of haircut. They accept a plan which gives them more resolution than the operational creditor, because even law treats financial creditors and operational creditors as unequals, right? The financial creditors are placed at an above pedestal than the operational creditors. But there is a last mechanism, the last section, which keeps a check on these actions of the financial creditors and the committee of creditors, right? Which is waterfall mechanism. The waterfall mechanism is nothing but it states out the priority in which the proceeds should be distributed, right? So it states that the insolvency, the CIRP cost to be paid first, then then the employees, the financial creditor, the employees, the workmen of the companies would get the priority in getting the proceeds, right? The proceeds, the priority of getting the proceeds of the payment are given under the section 53 of the waterfall mechanism. The waterfall mechanism also checks that the operational creditor cannot get less than the amount they would have gotten in case the company would have gotten under liquidation, right? So if the assets of the company surpasses the total debt of the company, then as per the liquidation you would have gotten your amount, right? Because all the assets are sold off in the event of liquidation, right? When the company goes into liquidation, all the assets and all the things that the company possesses are sold off, and the debts are paid, and the company is winded off, right? So the liquidation, in event the company would have gone into liquidation, and the amount you would have gotten in that event is the least amount that you would get even if the CIRP is successful, right? So you cannot get less than the liquidation amount in event of the liquidation. What you would have gotten, you cannot get less than that. Is what section 53 ensures, right? So the benefits and shortcomings of recourses under IBC. So I already stated that it is a arm twisting mechanism, because no one wants that the company are taken out of their hands, right? So as I already stated, the insolvency and bankruptcy code, what it does is it removes the faulty management. So no management wants the company to be taken out of their own hand and sold off to other party, right? So a lot of times when insolvency applications are filed, many companies promptly settle the issue because they do not want to enter insolvency, right? And the shortcomings are obviously because all the creditors under the MSMED Act would be considered as operational creditors under insolvency and bankruptcy code. They do not have decision making capacity when they opt for the recourses under IBC, right? Because the decision making capacity rests with the financial creditors, right? And the financial creditors would decide how much amount you would get, and which resolution plans will be successful. And you can only be guaranteed of an amount which is already there in section 53, which you would get in the event of liquidation. So that amount you can be sure of, but you cannot be sure that you would get the full realization of amount as you had expected in at the time of filing the insolvency application. The filing of claims before IRP, RP. So the forms are there. The form B specifically is for operational creditor. Form C is for workmen, employees, and all of those who are working in the company. So all the claimants have to file their claim in specific forms. For financial creditor, it's Form A. For operational creditor, it's Form B, and for employees and workmen, it's Form C. And for other creditors, the other forms are available, right? So you have to take care that the forms are properly filled, and after filling the information properly, and relying and attaching all the documents which you are relying upon for your claim, right? After doing all of those, you can submit those claims to the IRP or RP, right? And after analyzing, examining those documents and information, the RP accepts or rejects your claim. In case he accepts your claim, it would be reflected in the debtors list of the company. And in the case he rejects your claim due to some inconsistencies in the documents or information, you can have a recourse before NCLT because of such rejection. As I already stated, realization of amount due is not guaranteed based on the resolution plan, if any, or distribution of proceeds as per waterfall mechanism. So I believe that I was clear enough in dealing with the provisions of Insolvency and Bankruptcy Code. And now we'll move to the next slide. The resolution by way of alternate dispute resolution. So all the proceedings under the MSMED Act are governed by the Arbitration and Conciliation Act, right? So it is slightly important for you to understand in some provisions of Arbitration and Conciliation Act. However, these provisions are too much important, and a lot of judicial deliberations have already been done. And for me to give a detailed analysis, or to give a detailed understanding to all of you of these provisions under Arbitration and Conciliation Act, would take a lot more time than we have right now. So I'll just briefly touch upon the provisions. Section 9 is interim measures, etc. by courts. So there are a lot of times what happens is before the arbitral tribunal takes up your dispute, or decides your dispute, right? There are things which has to be protected uh, immediately, right? So there are interim measures. So in section 9, you can file an application for interim measures before court till the arbitral tribunal is not formed, or till the arbitral tribunal is not formed to hear the disputes. The section 11 is appointment of arbitrator, how the arbitrator is to be appointed. It is there in section 11(6), particularly 11 cross 6, and it states the process with which the arbitrators are appointed. Now in cases of MACFC, this this process of appointing arbitrator is taken care of by the MSMED itself, by the MSME department itself. And arbitration, uh, in cases of arbitration not governed by MSME, just the ad hoc arbitration, or institutional arbitration as per the arbitration agreement, the section 11 applies, right? So the section 11 is the provision which regulates the appointment of arbitrator. Section 16 is competence of arbitral tribunal to rule on its own jurisdiction. So many a times I've seen award in which the arbitral tribunal deals with limitation, or deals with maintainability. So a lot of times when we file a reference before the arbitral tribunal, the opposite party, without, in absence of knowledge, or in absence of uh, legal understanding, goes and file a writ petition before High Court saying that the MSME does not have any jurisdiction. So these cases are never entertained by the court because of this very section, which is section 66, section 16, which states that the arbitral tribunal itself is competent to rule on its own jurisdiction. So even if you had any questions on jurisdiction, if you think that the arbitral tribunal is not competent enough to deal with this issue, or this issue is outside the scope of this arbitration, or the outside the scope of the arbitration agreement itself, then those uh, jurisdictional issue are to be decided by the arbitrator tribunal himself, and not by other courts. So section 16 takes care of that. Section 17 is the interim measures, how it is before courts under section 19. Section 17 is before the arbitral tribunal. So when the arbitral tribunal is constituted, and after the constitution of arbitral tribunal, you needs any interim protection, any immediate relief, then you can file an application under section 17 before the arbitral tribunal, right? To get that interim measures. So for interim measures, the application before arbitral tribunal is under section 17. And I already stated section 34, which is the application for setting aside an arbitral award. It has limited grounds on which you can set aside an award, right? Conciliation is governed by Section 61 till 81 of the Arbitration and Conciliation Act. It is in different part 2 of Arbitration Act, if I'm not wrong. But it is in a whole different part than the arbitration. The arbitration falls into separate part, and the conciliation falls into the separate part. The filing of claim. So how do arbitral tribunal generally governs their proceedings, right? So they ask for statement of claim. They would ask you to provide them the statement of claim by stating that what all the claims that you have from the opposite party, how that claim, that how that debt, how that debt was how the debt how the debt fell due, and what was the brief history of the transaction, the circumstances of the transaction. All of these things to be stated in the statement of claim, and to be submitted before the arbitral tribunal. The arbitral tribunal then asks the other party to submit statement of defense or counter counterclaim, uh, counterclaim, and after that, basis on the statement of defense, counterclaim, that the counterclaim statement of defense, and the evidences that you produce, the submissions that you produce before the arbitral tribunal, basis on all these materials which are placed before the tribunal, or placed on record before the tribunal, it decides by analyzing all of those material, and accordingly passes an award, whatever he deems, as per whatever he deems fit, right? The seat, venue, and jurisdiction is important whenever you're drafting a arbitration clause in any arbitration agreement. You have to take care of the seat where the arbitration proceeding is to be held, the venue, the seat where which of which territory would have the jurisdiction, which courts would have the jurisdiction, which courts would have the first exclusive jurisdiction to deal with the arbitration, to deal with the suits arising from the arbitration, or the claims arising from the arbitration, or the disputes arising from the arbitration proceedings, right? And the venue is where the place where the arbitration proceedings should be conducted, and the jurisdiction is the which country's law would prevail, whether it would arbitration and conciliation 1996 India, or the UK King, the United Kingdom's Arbitration and Conciliation Act would govern. So all of these important clauses are to be looked into, and to be taken care of before drafting an arbitration clause, right? Moving to the next. Lastly, this is the most classic tool for recovering any amount, which is civil suit for recovery under Civil Procedure Code. Order 4 states the institution of suits, how suits are instituted, and it is it is it is the most basic way of recovering the money. And the benefits of this is, when that, like, a lot of times I've seen that your MSME registration certificate is of a prior date, is of a later date from the date on which you entered into a contract. And if you take a dispute arising from those contracts before MSCFC, the MSCFC would say to you that they do not have any jurisdiction because the registration was granted after the contract was entered into. So as per the Supreme Court's recent decision in Selfie Industries, it is now crystal clear and well settled that if you have an MSME registration post, after the date on which you have entered into contract with the other party, then that the disputes arising from that contract uh, cannot be governed by the MSMED Act, the provisions of MSMED Act. So in those cases, when you do not have any arbitration clause, any arbitration agreement for that matter, or do not have any registration in MSME, or have a registration of a later date, then only this recourse is available to you, which is the only recourse. So that's the only benefit. And the shortcomings are well known to all the other person, is that the kind of delay that it takes, the kind of amount of time that it takes for a civil suit to finally get decided by a court, right? In all over India, for that matter. So it's most time taking, as compared to all the other recourses that we discussed. And The jurisdiction for filing the civil suits are under section 18, which states that the other suits to be instituted where defendants reside. So if you are the claimant and if you are the claimant, then the jurisdiction would not be as per you. The defendant would have the jurisdiction, right? So the other party where it is situated would have the primary jurisdiction, or where the cause of action arises. So so the cause of action is a very complex term, which I'll have to make you understand, and it will take a lot of time if I attempted to make you understand that how cause of action is determined, whether it arises in one place or not. But let's just understand that if I have supplied goods to you, let's say from Patna to Delhi, and then it went from Delhi to Mumbai, and if the defendant resides in Mumbai, and the cause of action was arises in Delhi, like in like we cannot say that if the defendant states the goods were defect, uh, goods were defective, or not as per the terms and conditions, then we do not know whether at which point the cause of action arises, right? So it's all the places through which the goods have passed. All the places would have the same cause of action as Mumbai or Patna, for that matter, or as Delhi. So the way through which the goods passes, would all the places would have the same cause of action. So that is the way of understanding the term cause of action in CPC. So this is the civil suit for recovery, and order 37 is summary suits. Summary suits is nothing but an attempt of but an attempt for deciding and determining the civil suits in a timely bound manner. Summary suits are nothing but when you file a summary suit, the other party has to convince the court that why he should be given an opportunity to defend, at least. So you'd know that principles of natural justice has to be followed, right? No party can pass an award without hearing the other party, right? But the summary suits are an exception. Now, the summary suits are not for all the other disputes, right? If you have a dispute which is so much strong as per the documentation and records and everything that you have, that no possible dispute is is can be thought of by the opposite party. When the court sees that the opposite party has nothing to state, right? If let's say that the opposite party has given an acknowledgement that yes, I do have to pay you 18 lakhs of rupees, and now you have moved on summary suits for 18 lakhs, right? Now the opposite party cannot come and say that that the 18 lakh rupees is disputed, because he has already acknowledged to you, right? So in those cases where it is crystal clear that the opposite party do not have any practical defenses as to the dispute, then the summary suits the summary suits are proceeded with, right? The court denies them the right to defense, and according to your submitted materials and records, the court would decide and would pass a decision, right? And even if the opposite party succeeds in convincing the judge that he does have a practical defense, and he should be given the right to defend himself, then it's not like the summary suit gets dismissed. The summary suit gets converted into a normal suit. So it's a win-win situation. You can file a summary suit, and even if you fail, and the opposite party succeeds in convincing the judge that he must be given an opportunity to defend himself, then the summary suit would at best would be treated as normal suit, but it won't get dismissed. So that's all. This is the Commercial Courts Act jurisdiction, which is nothing but it came into force in 2015, and now all of the commercial matters are defined in the Commercial Courts Act. And after a specific value, after it exceeds 3 lakhs of rupees, that the dispute exceeds 3 lakhs of rupees, the Commercial Courts Act apply, right? And all the provisions are reflection The provisions of Commercial Codes Act are merely reflections of Civil Procedure Code with some modifications and modalities, like the summary suits in CPC are summary judgments in Commercial Codes Act, and all of the jurisdictions, like the jurisdiction as given under the CPC, are as the same under the Commercial Codes Act. So there is no need for uh, a separate substantiation in the provisions of Commercial Codes Act. So now I'll finish it. The quick tips and suggestions, the last slide. So I'll just briefly touch it, as we have already dealt upon this a lot of times. Always mention applicable GSTIN, UAN, PAN numbers on invoices because it's mandated by law. We do not we do not take much care of these small things, but all of these things, when you will go and take advice from any relevant professional, any professional working in specific industries, right? Such as CA, lawyers, or company secretaries, they would tell you that these things are pretty much important, right? Registered office address of both buyer and MSMEs. You have to have these much information because these informations are required also in filing the reference claim before MSCFC, right? Amount, payment terms, all of these things have to be crystal clear, right? The payment terms is to be there, the interest, how what interest is to be applicable. You have to tell the other party that you are an MSME, and if they delay, the interest applicable would be as per the MSMED Act. You have to maintain correspondences. You have to have a rectification defect quality clause and way of raising such defect default rectification process, reference to the payment agreement, etc. So all of these things I'm reiterating again, so that you have it in mind to take care of all of this, right? Invoices, communications has to be recorded, managed. Online way of communication, always communicate. As I already stated, that the communication goes a long way in setting the story straight, setting your claim straight, and reducing the scope of contradictions or possible other interpretations, right? Always have a pre-estimate of an amount which can be claimed as damages in case of delayed payments. So all of these liquidated damages, when you communicate, or when you are quick with your turnarounds, then you, as soon as you faces a loss, let's say, you had to pay any vendor a certain amount of money, but you were not able to pay that vendor just because your payment from any other supplier was delayed. So now you have to pay this vendor an interest component, right? So now you have to write an email to the supplier saying that just because your payment is delayed, I am not able to pay one of my vendors, and I have to additionally pay him the interest component. But it is not my fault, and the breach has done just because breach is attributed just to the supplier. So the interest component liability would not fall upon you, and with the claimed amount from the supplier, you can also claim the interest that you had to pay to the vendor just because of the delayed payment from that, right? So all these liquidated damages has to be kept in mind. Always try to settle amicably. So as I already stated, all these things entail financial resources, right? You'll go to a professional, that will entail professional charges. You'll file for reference, that will entail filing charges and clerkages and court fees, arbitral fees, conciliator fees. So it's always necessary to exhaust all the recourses that you have to settle it amicably on your own. And even if you have, and lastly, when you have given hope of resolving it amicably, then only you should come to way of resolving the disputes in alternatively, or through classical way of litigation, right? Last is always try to safeguard interest by registering trademarks, design mandatory compliances, and update statutory filings. So these things are not very much taken care of by the enterprises that I've seen, but all these things are safeguards you from a lot trouble that you might face in the upcoming future, right? By registering trademarks, I've seen people without trademarking their business, or without trademarking their brand, continue to operate, and they do not have any virtual recourse as to restrict the other parties to not use the same name. As you can go for passing off actions in CPC, but it has a wider uh, need or requirements to prove the passing off action. But registering trademark creates an asset, right? The trademark would belong to you. You can monetize it, you can sell it also. You can it can be used in n number of purposes, right? So all these intellectual property rights are very much important. And mandatory compliance, as I stated, for food business industries, the mandatory compliance are important. And for all the industry specific uh, sectors have their own compliances, right? If you're dealing in chemicals, you have to comply with the fire safety standards, national building codes, and all of those other things, the Factory Act, and the safety guidelines for the workers working in your company. If you have more than 10 members uh, working in a company, then you should have prevention of sexual harassment's internal compliance committee, which is mandated in law. So all these things you have to take care of, because you do not know of these compliances, and until and unless you approach a relevant professional consultant who deals with this, who has an expertise in all of these things, you won't get to know that your businesses requires all of these compliances. For example, there is one recent case by Supreme Court, in which the Supreme Court expressed its displeasure because almost all the government organizations also and the private organizations also do not have internal complaints committee, which is mandated under Prevention of Sexual Harassment Act at workplace. So if you have a woman or females working working at your workplace, and they're 10 in number, so you have to have an internal compliance committee constituted, and the reports of which annually is submitted to the DM. And if you do not comply to those provisions, the fine for each year is 50,000 rupees. So you can think that 2013 till to 2023, now it's 10 years. So if you have already not complied it for 10 years, the fine is already added up, like, right, 50,000 per year. So even if you comply it right now, I believe that the government would be liberal in letting go of these fines, because they are also not complying. But the Supreme Court has passed the direction, and it's already mandatory been directed to the government to take care of these things. So this is just an example, right? So you have to have all these compliances in your mind, because at a later stage, if you didn't know, and all these years you did not comply, then the fines for all those years is also added up, right? And whenever and at whenever at time you're caught, or when the compliances authority get hold of you and see that you have not complied with the mandatory compliances, you'll have to pay that amount, right? So all of these things are really important, and please do take care of these things. And with this, I'll end my webinar. Thank you so much. I hope that I was
Sir,
clear,
very informative
was
webinar.
effective.
सर कुछ पार्टिसिपेंट्स के क्वेश्चंस हैं, एक तो Q&A बॉक्स में
Sure, sure.
आप देख सकते हैं। भी पार्टिसिपेंट रिक्वेस्ट करूंगा, किसी को भी रिलेटेड टू वेबिनार कोई भी क्वेश्चन है सर से, तो आप अपना क्वेश्चन पूछ सकते हैं सर से। कमल चटर्जी।
हाँ हेलो।
हेलो, हाय तमल।
हाँ अच्छा, मेरा क्वेश्चन ये है कि कौन सा सबसे फास्टर एंड चीपेस्ट प्रोसेस है, माने लीगल प्रोसीड्योर में।
हाँ हाँ तमल, ये बहुत सारे फैक्टर्स पे डिपेंड करता है, जैसे कि आपका सर्कमस्टेंसेस पे भी डिपेंड करता है। आप अगर अगर ये कोई दूसरी पार्टी, ऑपोजिट पार्टी कंपनी या एलएलपी है, तब तो इंसॉल्वेंसी का मतलब कि इंसॉल्वेंसी
मेरा
एप्लीकेबल होगी।
सारा पार्टी आइदर कॉर्पोरेट और गवर्नमेंट है,
हाँ, okay, okay. So for the government departments, you cannot take the recourse under IBC, right? You understood, right? कि circumstances and factors पे depend करता है, और 1 करोड़ से ऊपर जब तक का आपका क्लेम नहीं रहेगा तब तक भी आप IBC नहीं जा सकते. तो मेरे हिसाब से जो बेस्ट recourse है, being an MSME is always MSEFC. आप क्यों ही जाएंगे आईबीसी में बीइंग एन ऑपरेशनल क्रेडिटर जब आपके पास गारंटी नहीं है कि वहां से मुझको कुछ मिलेगा या नहीं, या आप जितना क्लेम कर रहे हैं वो भी मिलेगा या नहीं. ये यहाँ पे लोग इसलिए जाते हैं क्योंकि अगर जो बड़ी कॉर्पोरेट्स होती है ना तमल, जो कि इंसॉल्वेंसी में नहीं जाएंगी किसी भी रीजन की वजह से, तो आप उनके खिलाफ अगर सीधा इंसॉल्वेंसी फाइल कर देते हैं तो उनका आर्म ट्विस्ट हो जाता है. तो इट इज नथिंग बट अ स्ट्रॉन्ग आर्म ट्विस्टिंग मैकेनिज्म. अगर कोई ऑपोजिट पार्टी आपकी बड़ी कॉर्पोरेट रेस्पेक्टेड कॉर्पोरेट है, तब आप इंसॉल्वेंसी के बारे में सोच सकते हैं, क्योंकि अगर आप इंसॉल्वेंसी फाइल करते हैं तो
एमएसएमई समाधान में एक केस लॉन्च किया था.
ओके.
उसमें बहुत ही जल्दी इसका रिजल्ट आ गया.
हाँ, श्योर. I told you कि it takes around 1 to 1.5 years in maximum. I have not seen any of the disputes being extended after 1 or 1.5 years. तो मतलब कि 1 या 1.5 साल एक डिस्प्यूट के लिए, मतलब कि इन इंडिया इज स्टिल वेरी लेस. तो ये MSCFC, yes, it indeed is a
ये
faster mechanism.
एमएससीएफसी तो समाधान है ना?
जी जी.
सेम. अच्छा, मेरा सेकेंड क्वेश्चन ये है कि मेरा एक केस आर्बिट्रेशन में है और एक मेरा सूट में है, ठीक है, कॉमर्शियल कोड में.
ओके ओके.
उसको मैं क्या ये एमएससीएफसी में ला सकता हूँ?
नो, वंस यू हैव ऑलरेडी प्रोसीडेड, अब आप वापस नहीं आ सकते. ये एक केस था ऑलरेडी. तो देखिए, ये ऐसे होता है कि आप एक साथ सारे जगह पे रिकोर्स नहीं ले सकते ना तमल. तो लॉ ऐसे आपको अलाउ नहीं करता है. तो अगर आप एक रिकोर्स में आगे बढ़ चुके हैं तो नाउ यू कैन नॉट कम बैक टू अदर रिकोर्स, राइट? तो अब जैसा आपका कमर्शियल,
मान लीजिए मेरा आर्बिट्रेशन अगर मतलब डिसमिस हो गया कि दिस इज नॉट अ केस ऑफ आर्बिट्रेशन, तो उसमें हम
then if the arbitration tribunal has stated कि we do not have jurisdiction to deal with this, then you can move to civil court or the commercial court, no problem. But
नॉट सिविल कोड, कमर्शियल कोड. मेरा एक केस है जो आर्बिट्रेशन में, ठीक है, वो चेंज ऑफ आर्बिट्रेशन के लिए गया है.
चेंज ऑफ आर्बिट्रेटर
और सिमिलर द सेम पार्टी, ठीक है, उसके साथ क्या हुआ, और एक केस में वो आर्बिट्रेशन रिफ्यूज हो गया और मैं उसको लॉन्च कर दिया कमर्शियल कोड में, राइट?
ओके ओके.
नाउ द सेकंड
that was the best recourse, Tamal.
हाँ, नाउ द सेकंड केस वेयर वो चेंज ऑफ आर्बिट्रेशन के लिए गया है हाई कोर्ट में केस. वो केस अगर डिसमिस हो जाता है, मैं क्या ऐसा अपील कर सकता हूँ हाई कोर्ट में कि मेरा केस आप डिसमिस कर दीजिए, मैं उसको एमएसएमई समाधान में लेके जाना चाहता हूँ? क्या प्रोसीड्यूर रहेगा इसमें, मतलब क्विक प्रोसीड्यूर क्या रहेगा?
ये आप बिल्कुल नहीं कर सकते तमल. मैं आपको रीजन बताता हूँ, सिंपल रीजन क्यों नहीं कर सकते आप. क्योंकि अगर आप MSCFC भी जाएंगे तो वो होगा आर्बिट्रेशन ही, क्योंकि वो गवर्न होता है आर्बिट्रेशन एक्ट से ही. तो कोर्ट आपको सीधा बोलेगी कि व्हाट प्रॉब्लम डू यू हैव in conducting the proceedings within this arbitration, and you are saying कि you'll go to MSCFC, क्योंकि हो तो रहा है आर्बिट्रेशन ही ना अल्टीमेटली.
हाँ, उसमें प्रॉब्लम क्या हो रहा है वो मैं बता सकता हूँ. मतलब बहुत ही प्रॉब्लम हो रहा है वो, मतलब वो सेक्शन 14
आपने फाइल किया है ना आर्बिट्रेटर चेंज करने का?
हाँ, मैंने फाइल किया है और सेक्शन 14,
आई अंडरस्टूड.
हाँ, वो बोल रहा है कि हम अभी सेक्शन 14 को ये इस नहीं करेंगे, मतलब ये आर्बिट्रेशन है कि नहीं, इसको हम बाद में जाके एकदम लास्ट में जाके बोलेंगे कि ये होगा कि नहीं. इसमें तो मेरा फीस चला जाएगा, मेरा टाइम चला जाएगा.
अच्छा, ओके. मतलब वो बोल रहे हैं कि मैं जुरिस्डिक्शन को लास्ट में डील करूंगा, मैं पहले मेरिट्स पे डील करूंगा.
हाँ, लेकिन मेरा सेम केस दूसरे जगह में हुआ है सेम पार्टी के साथ.
आई अंडरस्टैंड.
ऐसा ही बोला था,
बताता हूँ तमिल,
ऐसा ही बोला था और लास्ट में जाके उसने मेरा 2 साल बर्बाद करके बोला है कि नहीं, ये आर्बिट्रेशन में नहीं जाएगा.
हाँ, ऐसे होता है तमिल, ये बिल्कुल होता है, ये मैं जानता हूँ. बट इसमें एक रिकोर्स है आपके पास कि जब वो जुरिस्डिक्शन आपके खिलाफ डिसाइड करेंगे, अगर वो बोलते हैं कि मेरा जुरिस्डिक्शन ही नहीं है आर्बिट्रल ट्रिब्यूनल का, यहाँ पे आर्बिट्रेशन में नहीं जा सकता है ये, तो उनका पूरा फाइंडिंग्स जो भी था मेरिट पे, वो सब कुछ मतलब कि अब एप्लीकेबल नहीं होगा ना, क्योंकि आपने तो पहले ही तो बोल दिया कि मेरा तो जुरिसडिक्शन ही नहीं है। तो अब आप बाकी सारे इश्यूज पे भी कुछ नहीं बोल सकते, क्योंकि आप तो कॉम्पिटेंट ही नहीं है ये डील करने के लिए। तो अब आपका वो अफ्रेश हो गया है, मतलब कि उसमें कोई भी उनका अदर व्यूज वुड नॉट बी टेकन इनटू कंसिडरेशन। वो मैं समझ रहा हूँ कि आपका 2 साल लगा दिया उन्होंने ऐसे ये डिसाइड करने में कि इनका जुरिसडिक्शन है या नहीं, बट वो प्रोसीजरल ऑर्डर से होता है, वो आर्बिट्रल ट्रिब्यूनल आफ्टर प्लीडिंग्स और ये सब करके एक्सटेंड कर सकते हैं। मेनी टाइम्स थोड़ा से प्रेजुडिस भी होते हैं, तो इसी के लिए हमारे पास रिकोर्स भी है, जैसे कि आपने फाइल किया हुआ है चेंज ऑफ आर्बिट्रेटर के लिए, तो दिस कैन बी अ वैलिड ग्राउंड, यू कैन अप्रोच द हाई कोर्ट। एंड मैं तो आपको प्रेफर करूंगा कि आप हाई कोर्ट के सामने अच्छे से सबमिशंस दें कि और ये प्रॉब्लम आप हाई कोर्ट को बताएं, तो हाई कोर्ट वुड अंडरस्टैंड, एंड हो सकता है कि वो आर्बिट्रेटर चेंज भी कर दें। बिकॉज
ओके
आप जो बोल रहे हैं कि मैं वापस एमएससीएफसी में जाना चाहूंगा, दैट इज नॉट प्रैक्टिकली पॉसिबल नाउ व्हेन यू हैव ऑलरेडी मूव्ड टू arbitration and now you have filed an application to high court also, so now you cannot do it कि now I want to do it in MSCFC, so it's not allowed in law.
ठीक है, मैं एक सवाल पूछ सकता हूँ और?
हाँ हाँ बिल्कुल बिल्कुल, नो
देखिए
प्रॉब्लम।
हमारे लिए क्या है, हमारे लिए हम खुद चेक कभी कभी पार्टी को चेक इशू करते हैं फॉर सिक्योरिटी रीजन।
हाँ पीडीसी।
हाँ, तो
हाँ
मतलब सिक्योरिटी डिपॉजिट के लिए तो चेक वो विथड्रॉ नहीं करता है, लेकिन कभी एक दो बार ऐसा भी हो सकता है कि पार्टी ने जबरदस्ती ये चेक को मतलब बाउंस करा दिया, ये कुछ करा दिया करके, मतलब उस केस में हम क्या कर सकते हैं?
फिर उसमें आपको डिफेंस लेना पड़ेगा, सेक्शन 139 में आपको डिफेंड करना पड़ेगा अपना क्लेम।
अच्छा,
इसमें मैं आपको बताता हूँ, देखिए जैसे कि लाइबिलिटी तो
एमएसएमई का कोई
प्रिजम्पशन
कोई
तो
कोई
होता ही है,
हाँ,
प्रिजम्पशन तो होता ही है कि अगर आपने चेक दिया है तो आपने किसी लाइबिलिटी को एक्सटिंग्विश करने के लिए दिया था। तो
हाँ,
कोर्ट ऐसा करती है कि जब तक कि वो डिसाइड नहीं होता है, वो उतने चेक का अमाउंट आपको बोलेगी कोर्ट को डिपॉजिट कर देने के लिए। तो आप वो कोर्ट को डिपॉजिट करेंगे और उसके बाद कोर्ट डिसाइड करेगी पूरा सुन के आपका डिस्प्यूट, और अगर उनको लगता है कि ये चेक उनको नहीं करना चाहिए था टेंडर, या फिर ये किसी लाइबिलिटी के अगेंस्ट नहीं दिया हुआ है, तो वो मतलब कि वो जो अमाउंट है वो आपको वापस मिल जाएगा। लेकिन इफ यू लूज, देन द सेम अमाउंट दैट यू हैव deposited before the court will directly give it to the opposite party.
ओके, थैंक यू सो मच।
सर आप चैट बॉक्स में क्वेश्चन पढ़ पा रहे हैं? आशा जी का क्वेश्चन है, माय क्लाइंट हु इज बिल्डर has bypassed me although I have work order and took a form by another vendor for dumping my funds. Value is 10 lakh rupees. आई कनेक्ट आशा जी, आप क्वेश्चन पूछ सकते हैं।
So I can see 4 questions. Whether legal notice required to be sent before filing a complaint on MSME Samadhan portal? No, it is not required to send a legal notice. But it is a common accepted practice कि आप legal notice पहले दे देते हैं। आप बहुत बार केस फाइल कर देंगे, तो मतलब कि आप केस फाइल करने से अच्छा है कि आप एक बार लीगल नोटिस देके देख लीजिए। देर आर पॉसिबिलिटीज कि वो आके आपका सेटल कर ले, तो बस इसी के लिए, ये पॉसिबिलिटीज के लिए लोग लीगल नोटिस देते हैं कि हमें आगे लीगली ना जाना पड़े। देयर इज अ पॉसिबिलिटी कि अगर ये सेटल हो सकता है तो व्हाई can't we issue a legal notice first and wait for 10 days or 15 days, let's say. So that is the simple reason for it. Second, we have received an order for repair of ice plant at Lakshadweep Islands on 2019. The work has completed successfully, but the department has not settled our bills till date. So it's 2019. The limitation would have been till 2020. I'll need documents, the particular documents in order to answer this, because I do not have the work order, I do not have the bills, and I cannot, I do not know of any terms and conditions, but there is a possibility कि आपका ड्यूज जो है वो मिल जाए, क्योंकि अभी 1 ही साल का डिले हुआ है और अगर कोई एक्नॉलेजमेंट बीच में होगा या कोई ट्रांजैक्शन बीच में होगा तो वो एक्सटेंड भी हो जाएगा लिमिटेशन. इट्स नॉट अ बिग डील, बट I'll require more than this to give you a detailed reply, like the documents relating to the dispute. Please inform the procedure for collecting the delayed payment. I already informed the procedure for collecting the delayed payment. There are a lot of recourses which I already covered in the webinar. If you joined late, there are a lot of webinars on our YouTube from our channel UDYAMITA Helpline. You can just tune into UDYAMITA Helpline and you can get a hosts of videos that you can refer.
आशा
Can
जी क्वेश्चन पूछ सकते हैं?
Yeah, sure.
Hello.
Yes.
Hello.
Yes.
Sir, this is Asha. I just had thank you so much for your informative session. You clear most of our doubts, and
Thank you so much.
yeah, it was really informative. And I wanted to ask you, sir, that we are dealing with real estate market like builders, and we do firefighting installations for these builders, and we have completed the firefighting installations for one of such builder. And we have A form. A form is like after getting A form, he applies for final fire NOC. We wait for at every step for getting the payments, but the person is such a cheater. Like this happened second time with him. First, he had used a different name of developers, and they were different partners. And second time also, they were different set of partners. So we couldn't identify. Actually, we are dealing with the same fraud person, because unless and until the check comes to us, and when we see the signing authority, then we come to know, oh my God, we have signed a contract with another fraud person for the second time. So, already he had done such type of fraudism last a couple of cases, and this time he again succeeded doing it. That he had asked us to, he had given us the work order. We completed the task, and by the time we were waiting for our payments, like first payment, second payment, third payment, he took a long time to complete his to clear our payments. And then till the time we were waiting, that we were thinking that okay, he will pay maybe another this week, next week, 10 days, 15 days, he opted another vendor, and he bypassed us in spite having a contract. But he was not paying for the work which we have completed. I mean to say, if I have completed
I got you. I got your point.
out of 7 work, if I have done 5 and he has done 2, second vendor. Actually, in our firefighting contract, there is a law that you cannot appoint another vendor without taking NOC from the previous vendor. If you have cleared his dupes, the person will not give you NOC.
Okay.
So in that case, yeah.
Yeah, so Asha, I'll be very much honest with you. So with all the legal knowledge that I have, I for my first time I've come to hear this firefighting, all those laws that you stated, that you cannot take that you cannot go and take another vendor's help without getting an NOC from the previous vendor. So I'll check that law once, as to check that is there any recourse under that law for you, or you have the same recourses as we discussed earlier. So that is one point. If you have any recourse, and
this is a MFS law, Maharashtra Fire License. So when we renew our licenses, they say that you cannot issue license for third party. It has to be your own work. So we have already sent a notice to the guy who has done this. We have sent the notice or complaint to police officers, DCPs, senior police officers, as well as MFS, the association, and also to the person who issued A form. But I want to take action against the builder
for the delayed payment component.
Yeah. So I am raising a GST invoice for that, because I have done my work, and I'll get I'll send that GST invoice to him, and later can I claim for my payments?
If you have not raised any invoice till now?
No, I was waiting because I was making lot of fights.
So no problem. So what do the first thing that you raise an invoice, and you state that this invoice was to be raised earlier also, but anyway you mention this date, today's date in your invoice. You you state the brief dispute that all of these things have happened, but I am raising this invoice as of now, and please make my payment within 10 to 20 days, whatever suits you, whatever amount suits you, whatever amount of time suits you. And if he doesn't make any payment, you send him a notice for the payment, wait for 10 more days, and then just go and file a reference before MSEFC if you are an MSME.
And so any kind of small, what do you say, troubleshoot we required, whom can we connect with them?
Sorry, I did not get you.
Any kind of small troubleshoot, any queries if we have, then how can we connect? Do we have any kind
Oh,
of
you can
helpline?
connect to Megha or Richa. They'll tell you their contact number, and if you want my assistance or my consultation also, they'll connect you with me. No problem.
Okay, so is it available on the portal, sir, these numbers?
No, they'll release it here only, I guess, in the chat box, if I'm not
Okay,
wrong.
okay. Thank you so much, sir. Thanks a lot.
Okay.
Very kind of you. Thank you.
Thank you. Thank you.
Thank you so much, sir, for joining us.
Thank you. Thank you, Risha. It's always a pleasure.